Before we dive in, let's get one critical thing out of the way. The information provided in this video is for general informational purposes only and is not a substitute for professional legal or financial advice. The laws governing divorce vary significantly from state to state. I am not an attorney or a financial advisor, and this presentation is not intended to create an attorney-client relationship. You absolutely must consult with a qualified professional in your jurisdiction to get advice tailored to your specific situation. Making decisions based solely on this video could have serious legal and financial consequences. Please do your due diligence. You're lying in bed staring at the ceiling. It's 2 in the morning. The person sleeping next to you feels like a stranger, an ocean away. And the thought, the one you've been pushing down for months, maybe even years, bubbles up again, louder this time. Is this it? Is it over? And right behind that thought comes the wave of pure panic. A tsunami of questions. Where do I even start? Do I find a lawyer first? Do I move out? What do I say to the kids? To my family? How much is this going to cost? The sheer, crushing weight of the unknown is paralyzing. It's a feeling so overwhelming that for millions of Americans, it's easier to just stay stuck in misery than it is to face the fog of what comes next. This video series is the light that cuts through that fog. This is your roadmap, your step-by-step guide through the confusing, emotional, and legally complex maze of divorce in the United States. We are going to demystify the entire process, from this very first terrifying thought to the final signature on the decree. By the end of this series, you will not just understand the journey ahead. You will have a clear, actionable plan to protect yourself, your finances, your children, and your future. We are going to turn your panic into a plan. The first, most common mistake people make is thinking the first step is hiring a lawyer. It's not. The first step happens long before you ever speak to an attorney. It happens right now, in the quiet, in the uncertainty. It's the pre-decision phase, and what you do here can radically alter the entire course of your divorce. Right now, your brain is a cocktail of hurt, anger, fear, and maybe even guilt. These emotions are valid, but they are terrible strategists. A divorce at its core is the dissolution of a financial partnership. It is a business transaction, and you need to start thinking like a CEO of your own life, not a victim of your circumstances. You must shift from an emotional mindset to a logical one. This doesn't mean you become a robot. It means you acknowledge the emotions, you find a healthy outlet for them. A therapist, a trusted friend, a journal. But you do not let them drive the bus. Every major decision from here on out must be made with a clear head, based on facts and strategy, not on a desire to get even or react to a painful comment. Your goal is not to win a fight. Your goal is to achieve the best possible outcome for your future. So what's the first move for a CEO? They gather data. They get the facts. Your first mission, starting today, is to become a quiet, methodical information gatherer. You are going to create what we'll call a divorce binder, or a secure digital folder. This is your personal playbook, your arsenal of facts that will empower you and save you thousands of dollars in legal fees down the road. The more information you can hand to your lawyer, the less time they have to spend on expensive discovery. So what goes in this binder? Everything. I mean everything that touches your financial life as a couple. First, tax returns. Get the last 3 to 5 years of federal and state tax returns. These documents are a goldmine. They show reported income, investments, business ownership, and more. Next, bank statements. Gather at least the last 12 months of statements for every single account you and your spouse have, both joint and individual. Checking, savings, money market accounts, everything. You're looking for patterns of income, spending habits, and any unusual or large withdrawals or transfers. Now, investment and retirement accounts. You need statements for any 401(k)s, IRAs, pensions, brokerage accounts, stock options, or crypto wallets. You need the most recent statements you can find. These are often the largest assets in a marriage, and you need a clear picture of their value. Think about property. Find the deeds to any real estate you own, your primary home, rental properties, vacation homes. Get the most recent property tax assessments and mortgage statements for each one. Don't forget vehicles. Gather the titles and any loan statements for cars, boats, RVs, or any other vehicles. What about debt? This is just as important as assets. Collect the last 12 months of statements for every credit card, personal loan, student loan, and home equity line of credit. You need to understand the complete debt picture because liabilities are divided in a divorce too. Finally, gather your personal documents, your marriage certificate, birth certificates for you and your children, social security numbers, any prenuptial or postnuptial agreements, and copies of any wills or trusts you may have. I know this sounds like a mountain of paperwork. It is. But start now. Do it quietly and methodically. Make copies. Scan them and save them to a password-protected cloud drive that your spouse cannot access, or a thumb drive that you keep in a safe place, like at your office or a trusted friend's house. Do not do this on a shared family computer. Assume that everything you do on a shared device can be seen. This binder is your foundation. It's the single most powerful tool you have at this early stage. While you are gathering this information, there are a few critical things you must not do. The first and most common trap people fall into is moving out of the marital home. Unless there is a situation involving domestic abuse where your safety is at risk, in which case your first call should be to law enforcement or a domestic violence hotline, you should think very, very carefully before you pack a bag. In many states, voluntarily leaving the marital home can be seen as abandonment. This could potentially impact your claim to the house itself, and more importantly, it could set a dangerous precedent for child custody. By moving out, you are creating a new status quo where the children are living with your spouse full-time. A judge might be reluctant to change that arrangement later, arguing that the children are already settled. You might think you're just de-escalating the tension by leaving, but you could be unintentionally giving up massive legal leverage. Stay put, consult a lawyer first, and let them advise you on the right time and the right way to separate physically. The second thing you must do immediately is go on a total social media lockdown. Go dark. Stop posting. Better yet, deactivate your accounts for a while. Understand this. Anything you post can and will be used against you in a court of law. That picture of you having a glass of wine with friends? Their lawyer will frame it as you being an irresponsible partier. That vague, angry post you wrote? It will be Exhibit A to paint you as unstable and vindictive. That new friend you accepted a request from? It could be your spouse's cousin or a private investigator. Every check-in, every photo, every comment is a piece of evidence. Your spouse's attorney will be digging through your entire online history, looking for anything they can twist to their advantage. Don't give them the ammunition. The safest thing you can do is to disappear from the online world until the divorce is finalized. Finally, in this pre-decision stage, you need to start quietly identifying the members of your divorce team. You're not hiring them yet, you're just window shopping. You will need a top-tier family law attorney. Start asking for discreet referrals from trusted sources. Look for someone who specializes in divorce in your county, not just a general practice lawyer. You will likely need a financial advisor, specifically a certified divorce financial analyst, who can help you understand the long-term consequences of different settlement proposals. And crucially, you need a therapist or a counselor. A divorce is a marathon, not a sprint. It will test you mentally and emotionally. Having a professional in your corner to help you process the grief and stress is not a luxury. It's an absolute necessity to keep you grounded and focused on making logical, strategic decisions for your future. You see, the first step of divorce isn't an action, it's a preparation. It's about shifting your mindset from spouse to strategist. It's about arming yourself with knowledge, which is the ultimate power in this process. It's about building a fortress of facts and a support system before the first shot is ever fired. And once you have this foundation of information securely in your hands, you're ready to face the first major fork in the road, choosing the type of divorce you'll pursue. It's a decision that will dictate the cost, the timeline, and the level of conflict you're about to experience. From amicable mediation to a full-blown courtroom battle, the path you choose starts with understanding all of your options and knowing which one is right for your unique situation. So let's break down those options, starting with the simplest and most cost-effective path, the uncontested or DIY divorce. This is the unicorn of the divorce world. It's what everyone hopes for, but very few people actually qualify for. In an uncontested divorce, you and your spouse agree on absolutely everything. And I mean everything. How to split the bank accounts, who gets the car, who gets the debt, who gets the dog. And if you have children, you agree on a complete parenting plan and child support down to the last dollar. There are 0 points of disagreement. You're essentially just asking the court to legally rubber stamp the agreement you've already made. You might fill out the paperwork yourselves, maybe with the help of an online service, file it with the court, and after a waiting period, a judge signs off and you're officially divorced. It's clean, it's private, and it's incredibly cheap compared to the alternatives. But here's the reality check. This is really only suitable for short-term marriages with no children and very few shared assets or debts. The moment you have a house, a retirement account, or a disagreement about who gets the wedding china, the DIY path gets incredibly risky. Why? Because you don't know what you don't know. You might agree to a 50-50 split of a 401k without understanding the massive tax implications of how it's transferred. You might create a parenting plan that seems fair now but is completely unworkable in 2 years. Without professional guidance, you risk making catastrophic financial and legal mistakes that can haunt you for decades. So while the DIY divorce sounds great, approach it with extreme caution. If your situation has any complexity at all, you need to explore the next level up. And that next level is mediation. This is one of the most popular and effective routes for a reason. In mediation, you and your spouse hire a single neutral third party, the mediator, to help you negotiate a settlement. The mediator is not a judge. They can't force you to do anything. Their job is to be a facilitator, a guide, and a reality checker. They help you communicate, they explain the law in a neutral way, and they help you brainstorm solutions you might not have thought of on your own. You'll typically meet for several sessions, tackling one issue at a time. Property, then debt, then custody, then support. The goal is to work together to create a settlement agreement that you both can live with. The huge advantages of mediation are control, cost, and civility. You and your spouse, not a judge, are in control of the outcome. You get to decide what's best for your family. It's also significantly cheaper and faster than going to court, because you're splitting the cost of one professional instead of paying for 2 separate lawyers to fight against each other. And because the process is designed to be cooperative, it often preserves a functioning co-parenting relationship, which is priceless if you have kids. However, mediation isn't a magic wand. It only works if both parties are willing to negotiate in good faith. If there's a significant power imbalance, for example, one spouse has always controlled the finances and the other is in the dark, it can be difficult for the less powerful spouse to advocate for themselves. And crucially, mediation is absolutely not appropriate in cases involving domestic abuse, where the power imbalance is extreme and dangerous. The mediator is neutral. They are not there to protect you. In those situations, you need an advocate, which brings us to our next option. Let's talk about a process that many people haven't heard of, but that can be a game changer: collaborative divorce. Think of it as mediation with a support team and a critical safety net. In a collaborative divorce, both you and your spouse each hire your own specially trained collaborative attorney. Right at the beginning, everyone involved, you, your spouse, and both lawyers, signs a contract. This contract is a formal promise that you will not go to court. You will not threaten to go to court. The entire process is dedicated to settling the case respectfully and creatively, outside of a courtroom. If for some reason the process breaks down and one of you decides to file a lawsuit, both lawyers are legally disqualified from representing you any further. You'd have to start over from scratch with new litigation-focused attorneys. This no-court agreement is the magic ingredient. It completely changes the dynamic. Suddenly, your lawyers aren't incentivized to posture, threaten, or rack up billable hours fighting. Their sole job is to help their client reach a mutually beneficial agreement. The collaborative process also often involves a team of neutral experts. You might bring in a neutral financial specialist to analyze your assets and help you brainstorm division options in a clear, unbiased way. You might work with a divorce coach or a child specialist, both often mental health professionals, to help you manage the emotional turmoil and create a parenting plan that truly puts your children's needs first. It's a holistic approach. It's about dismantling the marriage and the finances in a way that causes the least amount of damage and sets everyone up for a successful future. It's more expensive than mediation because you have more professionals involved, but it is almost always significantly cheaper than the final option. It provides the support and advocacy of your own attorney, but within a cooperative, problem-solving framework. But what happens when cooperation just isn't possible? What happens when one person is hiding assets, when there's a history of abuse, or when you are so far apart on fundamental issues that no amount of negotiation will bridge the gap? That's when you enter the world of litigation. This is the process most people picture when they think of divorce. It's the classic adversarial system you see on TV. Each side hires a lawyer, a petition for divorce is filed with the court, and you are officially in the legal system. From this point on, a judge has the ultimate authority over your life, your children, your money, and your home. You are no longer in control. The litigation process is driven by strict rules and deadlines. It often begins with discovery, where lawyers exchange financial documents and information, sometimes demanding them through formal legal tools like subpoenas and depositions. There will be motions filed, court hearings to attend, and a constant back and forth between the attorneys, who are fighting to get the best possible outcome for their client. Now, it's important to know that even in litigation, something like 95% of cases still settle before ever reaching a final trial. But they often only settle on the courthouse steps, after months or even years of expensive and emotionally draining conflict. Litigation is, without a doubt, the most expensive, the most time-consuming, and the most emotionally destructive way to get a divorce. It can permanently poison any chance of a healthy co-parenting relationship and deplete the very marital assets you're fighting over. So why would anyone choose this path? Sometimes you have no choice. If your spouse is unreasonable, dishonest, or hiding things, litigation might be the only way to force transparency and protect your rights. It's the necessary last resort when all other avenues of cooperation have failed. It provides the power of the court to compel action, which is something no mediator or collaborative professional can do. Understanding these four paths, DIY, mediation, collaborative, and litigation, is the first, most critical strategic decision you will make. It sets the tone for everything that follows. So let's break down what that really means on the ground. Because before you can even walk down one of those four paths, you have to take the first legal step. The one that officially starts the clock and changes your legal status from married to in the process of divorce. This step is the filing of the petition for dissolution of marriage. That's the legal term for it. You might call it filing for divorce. The person who files this initial document is called the petitioner. The other spouse who receives the papers is called the respondent. Now, don't read too much into these labels. Being the petitioner doesn't give you an advantage. It doesn't make you the good guy or the winner. It just means you were the one who went to the courthouse or had your attorney go and got the ball rolling. In many amicable divorces, couples decide together who will file, simply as a matter of logistics. This petition is a relatively simple form, but it's powerful. It's a formal request to the court to legally end your marriage. On it, you'll state basic information: your names, the date you got married, the date you separated. And crucially, you'll have to state the legal grounds for the divorce. Now, this is a point that trips a lot of people up thanks to old movies and television shows. They think they need to prove someone did something wrong: cheating, abandonment, cruelty. This is what's known as a fault divorce. And while a handful of states still have fault grounds on the books, the reality is that every single state in the US now offers some form of no-fault divorce. No fault is exactly what it sounds like. You don't have to prove anyone was the bad guy. You just have to state that the marriage is over. The most common legal reason cited is irreconcilable differences or irretrievable breakdown of the marriage. This is a legal way of saying, we just don't get along anymore, and there's no reasonable chance of us fixing it. That's it. It allows you and your spouse to end the marriage with a measure of dignity, without having to air your dirty laundry in a public court record. So why do fault grounds even exist? In some states, proving fault like adultery might influence decisions about alimony or, in very rare cases, property division. But it's a messy, expensive, and often traumatic road to go down, and most attorneys will advise against it, unless there's a very specific strategic reason. For the vast majority of Americans, your divorce will be no fault. It's not about blame. It's about untangling a legal and financial partnership. Before you can even file that petition, though, you have to meet what are called residency requirements. This is incredibly important. You can't just file for divorce in any state you feel like. The state court has to have jurisdiction, the legal authority, over your marriage. To get it, at least one of you must have lived in that state for a certain amount of time. In California, for example, you have to be a resident of the state for 6 months and a resident of the specific county you're filing in for 3 months. In Texas, it's 6 months in the state and 90 days in the county. In Florida, it's 6 months in the state. Every state is a little different. So the very first thing you need to do is a simple online search for divorce residency requirements in your state. This is non-negotiable. If you file without meeting the requirement, the court will throw out your case, and you'll have wasted time and money. This is especially critical for couples who live in different states or have recently moved. You have to file where one of you has established legal residency. Okay, so you've met the residency requirement, you've filled out the petition for dissolution, citing no-fault grounds. You've filed it with the court clerk and paid the filing fee, which can be several $100s. Now, the process is officially underway. But the court can't do anything yet. Why? Because the other person, the respondent, has to be formally notified that a lawsuit has been started against them. This is a cornerstone of the American legal system called service of process. It ensures that everyone has a right to know they're being sued and has an opportunity to respond. This is the part that causes so much anxiety. The dramatic movie scene where a stranger walks up and says, "You've been served," and slaps a bunch of papers into the person's hand. While it can happen that way, it often doesn't have to. The goal is simply to have legal proof that the respondent received a copy of the filed petition. There are a few ways to accomplish this. The most amicable and cheapest way is called acceptance of service or waiver of service. This is common in DIY, mediated, or collaborative divorces. You simply give the papers to your spouse, and they sign a form in front of a notary acknowledging they received them. That form gets filed with the court, and service is complete. It's cooperative and non-confrontational. If that's not possible, the next step is personal service. You cannot serve the papers yourself. That's a conflict of interest. You have to use a neutral third party who is over 18. This could be a friend or family member, but it's generally a bad idea to put them in that awkward position. The professional options are to hire the local sheriff's department or a private process server. They will take the documents, go to your spouse's home or workplace, and hand them the papers. They then fill out a proof of service form, which gets filed with the court. This process isn't meant to be embarrassing or aggressive, though it can certainly feel that way. It is simply a necessary legal step to ensure the process is fair. Once your spouse has been served, another clock starts ticking. The respondent has a limited amount of time to file their own document with the court, called a response or an answer. The deadline is different by state, but it's often around 20 to 30 days. The response is their opportunity to tell the court they agree or disagree with what was stated in the initial petition. Do they agree on the date of separation? Do they agree on the list of assets and debts? It's their chance to participate in the case. And this is a critical warning. If your spouse files for divorce and you are served with papers, you absolutely cannot ignore them. I repeat, do not ignore them. If you fail to file a response within the legal time limit, the petitioner can ask the court for a default judgment. This means the court can move forward with the divorce without any input from you. The judge can, and likely will, grant the petitioner everything they ask for in their petition regarding property, debt, support, and even custody of your children. It is a devastating and almost entirely avoidable mistake. Even if you and your spouse are working things out in mediation, it is crucial to file that response to protect your legal rights. So, you have the petition filed by the petitioner, and the response filed by the respondent. These two documents open the case. They frame the issues the court will need to help you resolve. How you get to that resolution goes back to those four paths. In litigation, these filings are the opening moves in a strategic legal battle. In mediation or a collaborative case, they are often seen as a necessary cooperative step in a process you are both navigating together. But the moment that first petition is filed with the court and served on the other party, something else happens automatically, something that has a massive and immediate impact on your life. In many states like California, they're called automatic temporary restraining orders, or ATROs. In other states, they're called statutory injunctions. Whatever the name, the effect is the same. The moment the divorce begins, a legal freeze is placed on your entire financial life. It prevents you from selling assets, emptying bank accounts, changing beneficiaries on your insurance, or taking out new loans without your spouse's permission or a court order. And most people have no idea it's coming. And when it does come, it feels like a gut punch. One moment you're living your life, and the next, a stranger hands you a stack of papers that officially detonates it. Your hands might shake as you read the words, "Dissolution of Marriage." Doesn't feel real. But that stack of papers in your hand isn't just a symbol. It's a legal command. And it has started a clock. Right now, in this moment of shock and confusion, you have to understand this. You are now on a deadline. In most states like California, for example, you have exactly 30 days from the date you were served to file a formal legal response with the court. 30 days. That's it. This isn't a suggestion. It's a hard and fast rule. And ignoring it is arguably the single most catastrophic mistake you can make at the beginning of your divorce. So what is this response? It sounds confrontational, doesn't it? Like you're supposed to write a long, angry letter detailing every single thing your spouse did wrong. It's not. The legal system, for the most part, doesn't care about the drama. It cares about procedure. The response, officially called a response and request for dissolution of marriage in many places, is a legal document. It's your formal answer to your spouse's petition. It's your way of raising your hand and telling the court, "I'm here. I'm participating. I have a voice in this process." Think of the petition your spouse filed as their opening move in a chess game. They've laid out what they want the final board to look like, how they want to divide the assets, who they think should have the kids, whether they think they should receive or pay support. Your response is your opening move back. It's a form that largely mirrors the petition, and it's your chance to tell the court what you want. You go through point by point and state your position on property, on debt, on custody, on support. You don't have to have it all figured out. In many sections, you can simply state that the full nature of the assets and debts is unknown and needs to be determined. The key is that you are formally registering your disagreement or your own set of requests. You are preserving your rights to be heard on every single issue. Filing this document is what makes you an active participant. Without it, you're just a spectator to your own life being dismantled. And this brings us to the terrifying alternative. What happens if you miss that 30-day deadline? What if you're too overwhelmed, or you put the papers in a drawer hoping they'll go away, or you think that by ignoring them you're not agreeing to the divorce? If you fail to file a response in time, your spouse can file a request with the court to enter a default against you. And a default is exactly what it sounds like. You lose by default. You forfeit the game. It's the legal equivalent of not showing up for the Super Bowl and expecting to have a say in the final score. Once a default is entered, you have effectively been silenced. You lose your right to participate in the divorce proceedings. You don't get to file financial disclosures, you don't get to argue in court, you don't get to present evidence. The judge will proceed with the case based solely on the information and requests provided by your spouse in their initial petition. Let me be crystal clear about what this means. If your spouse asks for the house, the car, and full custody of the children, and you get defaulted, the judge can, and very likely will, grant them the house, the car, and full custody of the children. If they ask for a certain amount of spousal support, the judge can order it. If they claimed a piece of property was theirs alone, the judge can award it to them without ever hearing your side of the story. A default judgment is a legally binding and final court order. It is incredibly difficult and sometimes impossible to undo. I have seen people lose their homes, their retirement savings, and even their relationships with their children because they failed to file one simple document on time. Do not let this be you. So the very first fork in the road appears the moment you're served. You have a choice. Path 1 is the uncontested divorce. This is where you and your spouse are generally in agreement on all the major issues. You still need to go through the legal process, and you, the person who was served, will still likely file a response. But you're doing it as part of a cooperative process. You've already talked, you've worked out the details, and you're just using the court system to make your agreement official. This is the ideal scenario. It's faster, cheaper, and infinitely less stressful. But for many, that's not reality. That leads to path 2, the contested divorce. This simply means you and your spouse do not agree on one or more major issues. It could be one small thing or it could be everything. In this case, your response isn't just a formality. It's the foundational document for your entire case. It's your first official act of advocacy for yourself. It's where you draw your lines in the sand and state what you believe is fair and just. From this point forward, the process will involve negotiation, mediation, and possibly litigation to resolve those disagreements. Regardless of which path you think you're on, your immediate actions after being served are critical. First, take a deep breath. Read every single page you were given, especially those automatic temporary restraining orders we talked about. Understand the new rules you're living under. Second, start gathering documents. Quietly and calmly, begin making copies of everything financial: bank statements, credit card bills, mortgage documents, car loans, pay stubs, tax returns for the last 5 years. You need a complete picture of your marital financial life, and you need it now. This isn't about hiding anything. It's about arming yourself with knowledge. Knowledge is power in this process. And the third and most important step is to seek legal advice immediately. Do not wait. Do not think you can handle this on your own because you and your spouse are amicable. Even a single consultation with a qualified family law attorney in your state can be the most valuable money you will ever spend. They will read the petition, explain what it means in your specific situation, tell you your exact deadline for filing a response, and lay out your options. An attorney can help you understand your rights and your obligations. They can spot issues you would never think of, like how to properly value a pension or a business, or the tax implications of keeping the house. Choosing not to get legal advice at the beginning of a divorce is like deciding to perform surgery on yourself after watching a few YouTube videos. You might get lucky, but the potential for a life-altering mistake is enormous. The person who filed for divorce has almost certainly spoken to a lawyer already. They started this process with a plan. By serving you those papers, they've made their first move. It is now absolutely essential that you formulate a plan of your own. Your future, your finances, and your family depend on the decisions you make in the next 30 days. The clock is ticking. What you do next will set the stage for everything that follows. So let's talk about that stage. The very first move is not what you think. It isn't a dramatic confrontation. It isn't a tearful confession. And it's definitely not a call to the most aggressive lawyer you can find on a billboard. The first, most critical move is silence. It's observation. It is the beginning of what I call your information offensive. This is the phase where you become a quiet, methodical archaeologist of your own life. You are not being sneaky. You are not being deceptive. You are being responsible. You are gathering the fundamental facts of your shared existence, because very soon, those facts will be divided, scrutinized, and assigned a value. Your first mission is to assemble a complete, unvarnished picture of your financial life. This is non-negotiable. You need to gather, copy, and secure documents. Not tomorrow. Not next week. Now, we're talking about the last 3 to 5 years of your joint and individual tax returns. These documents are the Rosetta Stone of your marriage's finances. They show reported income, investments, deductions, and business interests. They tell a story that memory often forgets. Find them, scan them, save them to a secure cloud drive that only you can access, or make physical copies and store them somewhere safe outside of your home. A trusted friend's house, a family member's, or a new safe deposit box. Next, bank statements. All of them. Checking, savings, money market accounts. At least the last 12 months, but more if you can get them. You're looking for patterns. Regular deposits, unusual withdrawals, transfers to accounts you don't recognize. This isn't about looking for wrongdoing necessarily. It's about understanding the cash flow of your household. Where does the money come from and where does it go? The same goes for credit card statements. Every single one. Joint cards, individual cards that are paid from a joint account. This is a detailed diary of your lifestyle. It shows spending habits, travel, major purchases, and recurring expenses. This information will be vital when it comes to creating budgets and discussing things like alimony or child support. Then you move to the bigger picture. Investment and retirement account statements. For 401(k)s, IRAs, brokerage accounts, pension statements. Get the most recent quarterly and annual statements you can find. For many couples, these are the largest assets they own, even bigger than their house. You need to know what exists and what it's worth. Don't just assume you know. Find the paperwork. And speaking of the house, find your mortgage statements, property tax bills, and the deed to your home if you have it. The same goes for any other properties you own. Get the titles for all vehicles, cars, boats, RVs. Get loan statements for everything: car loans, student loans, personal loans. You are building a complete balance sheet of your life. Assets on one side, debts on the other. This ledger of your marriage is the foundation upon which your entire divorce settlement will be built. Without it, you are flying blind in a hurricane. While you're gathering these financial records, you also need to collect crucial personal documents. Your marriage certificate, of course, birth certificates for yourself and your children, social security cards for everyone in the family, passports, any immigration or citizenship paperwork. If you have a prenuptial or postnuptial agreement, locate it immediately. This document could fundamentally alter the entire course of your divorce. Read it. Understand it. It may feel like a relic from a different lifetime, but its power is very, very real. Now let's talk about the modern battlefield, your digital life. This is where so much of our financial and personal information now lives, and it's an area people frequently overlook until it's too late. Make a list of all shared online accounts. Not just banking and credit cards, but everything. Amazon, Netflix, utility bills, cell phone plans, cloud storage like iCloud or Google Drive. Who has the master password? What information is stored there? If you share a computer, be aware of saved passwords in the browser. If you have a family cell phone plan, who is the primary account holder? That person can often access call logs and text records. This isn't about digital espionage. It's about understanding your vulnerabilities and securing your own privacy. This is the time to change the passwords on your personal email and your individual social media accounts. Create a new private email address that will be used only for communication with your lawyer and for setting up your new independent life. Do not use a shared computer or a device your spouse has access to for these communications. The digital walls you build now will protect you later. Now, as you embark on this information offensive, I need to give you a critical warning. A bright, flashing red light. While you are gathering, copying, and scanning, you must not, under any circumstances, start moving assets. Do not take half the money out of the joint savings account and put it in a new account in your name only. Do not sell stock. Do not pay off a personal credit card with a huge chunk of money from a joint account. Doing this can be seen by the court as dissipation of assets. It's a legal term for wasting, hiding, or improperly using marital funds in anticipation of a divorce. It makes you look like you're acting in bad faith. It destroys trust, invites suspicion, and can result in a judge penalizing you severely in the final settlement. They might award your spouse a larger share of the remaining assets to make up for what you took. So for now, your mantra is observe, don't disturb. You are a librarian, not a bank robber. You are documenting the state of the union, not dissolving it prematurely. Think of what you're creating as your life file. It's a binder, a box, a secure digital folder that contains the complete blueprint of your life up to this point. I know this process is daunting. Sifting through these papers is like an archaeological dig of your own heart. Each document, a mortgage for a first home, a loan for a family car, a credit card statement showing a special anniversary dinner, is a fossil of a life you built together. It will be painful. Allow yourself to feel that, but understand that this pain has a purpose. You are transforming confusion into clarity. You are replacing fear of the unknown with the power of the known. This life file is your single most powerful tool. When you finally do sit down with an attorney, you won't be walking in empty-handed, overwhelmed, and unsure. You will walk in with a comprehensive portfolio of your financial reality. You will be organized. You will be prepared. You will save yourself and your lawyer countless hours and thousands of dollars in fees that would have been spent just trying to track all this down. You will be starting from a position of strength and knowledge. You've now mapped the entire financial landscape of your marriage. You have the documents, the data, the facts. You've done the quiet, difficult work that most people skip. But this is just the raw intelligence. It's the map of the world as it is today. The next step is to use this map to chart a course into your new world. It's time to stop just looking at the past and start building the infrastructure for your future. And that begins with one of the most important and often emotionally charged steps you will take. Establishing your own financial independence, starting with a bank account that is yours and yours alone. It's time to build your own fortress. This fortress isn't just about walls. It's about having a treasury that only you control. Opening a separate bank account in your name only is not an act of aggression. It's an act of profound self-preservation. It's the financial equivalent of putting on your own oxygen mask first. This account becomes the new destination for your paycheck. As soon as possible, you should contact your employer's human resources department and change your direct deposit information. Every dollar you earn from this point forward should flow into an account that your spouse cannot access, cannot freeze, and cannot empty. Why is this so critical? Because in the chaos of separation, joint accounts can become a battleground. We've seen it 1,000 times. One spouse, out of fear or anger, withdraws the entire balance, leaving the other with nothing to pay the mortgage, buy groceries, or put gas in the car. It's a devastatingly effective, and unfortunately common, tactic. By establishing your own account, you create a financial safe harbor. You ensure you have the funds to live, to pay for a consultation with an attorney, and to begin operating as an independent financial entity. When you go to the bank, bring your driver's license, your social security card, and proof of address. Open a checking and a savings account. Opt out of overdraft protection for now. You want to be hyper-aware of your balance. And keep the existence of this account to yourself until you've spoken with your lawyer about the appropriate time to disclose it. This isn't about hiding assets. It's about securing your immediate liquidity and safety. Now, with the treasury secured, we need to man the watchtower. You need to become the guardian of your credit. Your financial life and your spouse's have been intertwined for years, and that includes your credit history. Joint credit cards, car loans, mortgages, these are shared obligations. And here's the terrifying truth. Even if a judge orders your spouse to pay a certain joint debt, if their name is on the account alongside yours, the creditor can still come after you if your ex-spouse fails to pay. Your credit score, your ability to one day rent an apartment or buy a home of your own, is directly tied to their financial responsibility until these joint accounts are closed or refinanced. Your first move is to get a complete, unvarnished look at the battlefield. Go to annualcreditreport.com. This is the only official, federally authorized site to get your free credit reports from all three major bureaus: Equifax, Experian, and TransUnion. Don't use other sites that promise free scores but are really just trying to sell you something. Pull all three reports. They might look slightly different, but together they paint a comprehensive picture. Print them out. Get a highlighter. Go through every single line item. You are looking for three things. First, every account that has your name on it. Second, you're identifying which of those are individual accounts and which are joint accounts. A joint account means you are both equally and 100% responsible for the entire debt. Third, you're looking for surprises. Are there cards you forgot about? Loans you didn't know existed? Late payments you weren't aware of? This is your moment of truth. Once you have this list, you need to take defensive action. For any joint credit cards, you need to call the creditor immediately. Tell them you are in the process of a divorce and you want the account frozen to any new charges. This is crucial. It prevents a spouse from running up massive debt in a fit of anger or desperation. Debt for which you would be legally responsible. They can't close the account without both parties' consent, but they can and should prevent new charges from being added. Next, you need to understand the difference between being a joint account holder and an authorized user. If you are merely an authorized user on your spouse's card, you can simply call the credit card company and have your name removed. This severs your connection to that debt instantly. If you are a joint account holder, it's more complicated. The debt must be paid off and the account closed, or one person must refinance the debt into their own name. This will become a major point of negotiation in your divorce. While you are untangling the past, you must simultaneously start building your future. If you don't have a credit card in your own name, get one. Now, even if it's a secured card with a small limit of a few $100s. Use it for a small recurring charge each month like a Netflix subscription, and pay the bill in full every single time. This activity begins to build a credit history that is solely yours. It demonstrates to the financial world that you are a reliable, independent individual. This single step can be the difference between getting approved for a new apartment or being denied. Your credit score is your reputation in the financial world. Guard it fiercely. With your personal treasury established and the watchtower manned, it's time for the most laborious, but perhaps the most important task of all. You must gather the intelligence. You need to create a complete inventory of the marital financial estate. Think of yourself as a cartographer, mapping every river of income, every mountain of assets, and every valley of debt. Your attorney will call this the discovery process, but you can and should start long before that. You are looking for documents, paper trails, the undeniable proof of your shared financial life. Start with the basics. Gather at least the last 3 and ideally 5 years of tax returns. These are treasure maps. They show sources of income, investments, business interests, and property. Next, collect at least 1 year's worth of bank statements for every single account, checking, savings, money market, everything. Do the same for all credit card statements. You need to see where the money has been coming from and where it has been going. Then you move to the larger assets. Find the most recent statements for all retirement accounts, 401ks, 403b(s), IRAs, pensions. These are often the largest assets in a marriage besides the house. Get statements for any brokerage or investment accounts holding stocks, bonds, or mutual funds. Find your mortgage statements, property tax bills, and the deed to your home if you can. Get the titles and loan statements for all vehicles, cars, boats, RVs. Don't forget insurance. Life insurance policies with cash value are assets. You need to know who the beneficiaries are. You also need copies of health, auto, and homeowners insurance policies. Where do you find all this? Start with the filing cabinet, the home office, the desk drawers. But increasingly, most of this exists online. If you have access to the online portals, log in. Download the PDF statements for the last 2 to 3 years. Do not just assume you'll have access tomorrow. Passwords can be changed in an instant, locking you out of your own financial life. As you gather each document, make a copy. Scan it and save it to a secure cloud drive like Dropbox or Google Drive, protected with a new password your spouse doesn't know. Also, make a physical copy and store it somewhere safe outside of the marital home. Give a folder to your parents, a trusted sibling, or your best friend. Do not leave your only copies where they can be accidentally shredded or lost. This process may feel overwhelming. It may feel sneaky. It is neither. It is your right to have access to your own financial information. This documentation is the foundation upon which your entire divorce settlement will be built. It ensures a fair and equitable division of assets. It prevents things from being hidden or undervalued. It empowers you and your attorney to negotiate from a position of strength and knowledge, not from a position of ignorance and fear. Taking control of your money, your credit, and your financial information are the first 3 pillars of building a new independent life. It's not just about ending a marriage. It's about beginning your own story fully funded and fully aware. And the next chapter begins with understanding the legal landscape you're about to step into. So, what does this legal landscape actually look like? Forget the dramatic courtroom scenes you see in movies for a moment. At its core, the legal process of divorce is just that, a process. A series of steps with a clear beginning, middle, and end, designed to formally and fairly dissolve a legal partnership. It starts with a single document, usually called a petition for dissolution of marriage. One person, the petitioner, files this with the court. This document doesn't need to be an accusation. It's simply a formal statement that the marriage is irretrievably broken and a request for the court to legally end it. Once this is filed and then delivered or served to the other spouse, who is now the respondent, the legal clock starts ticking. From this starting point, the path of your divorce will diverge into one of a few main channels. Think of it like a river splitting. The first and calmest channel is the uncontested divorce. This is the path you take when you and your spouse agree on everything. And I mean everything: how to divide the property and debts, the plan for custody and parenting time if you have children, and the terms of any spousal or child support. You're essentially presenting the court with a finished puzzle. You've worked it all out yourselves, written it down in a formal agreement, and you're just asking the judge to sign off on it, making it legally binding. This is, without a doubt, the fastest, cheapest, and least emotionally draining way to get divorced. It minimizes conflict and keeps you and your spouse in control of the outcome, rather than handing that power over to a judge who doesn't know you or your family. But what if you can't agree? What if you agree on the house but not on who gets the retirement account? Or you agree on custody but are miles apart on child support? This is where you enter the second channel, the contested divorce. The word contested sounds aggressive, and it can be, but it simply means there is at least one major issue you haven't been able to resolve on your own. This is where the legal system truly kicks into gear. This path involves a phase called discovery, which is exactly what it sounds like. It's the formal process where both sides exchange all relevant information. We're talking bank statements, pay stubs, retirement account information, property deeds, tax returns, everything that paints a full financial picture. The goal of discovery is to make sure no one is hiding assets, and that any decisions are made with all the cards on the table. Following discovery, there will be negotiations, settlement conferences, and attempts to reach a compromise. The vast majority of contested divorces, over 95%, still settle out of court. They eventually reach an agreement through this process. Only a tiny fraction actually go all the way to a trial, where a judge hears evidence from both sides and makes the final decisions for you. Now, it's not just a binary choice between total agreement and total war. There are incredibly valuable middle paths. One of the most common is mediation. In mediation, you and your spouse hire a neutral third party, the mediator, to help you negotiate. The mediator doesn't make decisions for you and isn't a judge. Their job is to facilitate communication, help you identify the issues, brainstorm solutions, and guide you toward a mutually acceptable agreement. It's a confidential, structured negotiation process that can save you a fortune in legal fees and immense emotional stress. It keeps the decision-making power in your hands. Another option gaining popularity is the collaborative divorce. This is a team-based approach. You each have your own specially trained collaborative attorney, but you all agree in writing to work together to reach a settlement without going to court. You might also bring in other neutral professionals, like a financial specialist to help with the numbers or a child psychologist to help craft a parenting plan. It's a holistic approach designed to solve problems creatively and preserve a functional co-parenting relationship. It's structured, supportive, and focused on the future, not just on winning battles from the past. Understanding which path you're on is crucial, but regardless of the path, you'll encounter a specific vocabulary. Let's quickly demystify a few key terms. We've mentioned the petition, which starts the process. We've talked about discovery, the information gathering stage. Another critical concept is temporary orders. Life doesn't just pause the moment a divorce is filed. Who pays the mortgage this month? Where will the kids sleep on Tuesday? Temporary orders are a way to answer these immediate questions. They are short-term rules put in place by a judge to govern things like custody, child support, spousal support, and who gets to live in the marital home while the divorce is still in progress. They're a legal stopgap to maintain stability until a final agreement is reached. The final agreement itself is usually called a marital settlement agreement, or MSA. This is the holy grail of the divorce process. It's the comprehensive final contract that lays out every single detail of your divorce settlement. Once signed by you, your spouse, and a judge, it becomes a legally enforceable court order. Now for one of the most important things you need to understand. Divorce law is state law. There is no federal divorce law in the United States. This means the rules, procedures, and formulas that apply to you depend entirely on the state where you file. This is a massive detail. For example, states are generally divided into two camps for dividing property: community property states and equitable distribution states. In community property states like California or Texas, marital assets are generally split 50-50 straight down the middle. In equitable distribution states, which is the majority of states, assets are divided fairly or equitably, which doesn't always mean 50-50. A judge might consider factors like the length of the marriage, each person's earning capacity, or who was the primary caregiver to the children, and decide that a 60-40 or 70-30 split is more fair. The formulas for calculating child support also vary wildly from state to state. The waiting periods before a divorce can be finalized are different. The definitions of what constitutes marital property can change. This is why you can't just take advice from a friend who got divorced in another state. Your first and most important piece of legal research should be to look up the basic divorce laws for your specific state. This brings us to the big question. Do you need a lawyer? The honest answer is, it depends. If you're having a truly simple, uncontested divorce, no kids, no real estate, minimal assets, short-term marriage, and you're both in complete agreement, you might be able to navigate the process using your state's court-provided forms, perhaps with the help of a paralegal or an online service. However, even in the simplest cases, it is incredibly wise to have an attorney at least review your final agreement before you sign it, just to make sure you haven't missed anything or accidentally given away your rights. But if your divorce involves any level of complexity or conflict, if there are children, a house, retirement accounts, a business, or any disagreement on major issues, trying to represent yourself is like trying to perform your own surgery. You simply don't know what you don't know. A good family law attorney is not just a fighter. They are your guide, your strategist, and your advocate. They know the specific laws of your state, they know the local judges, and they can protect you from making costly, irreversible mistakes. And if there is any history of domestic violence, control, or a significant power imbalance in your relationship, getting a lawyer is not optional. It is an absolute necessity for your safety and your future. The legal system can seem intimidating, a maze of confusing forms and arcane rules. But viewing it as a structured process with distinct paths and a clear vocabulary can strip away much of that fear. It's a tool, and your job is to learn how to use that tool effectively to build the foundation for your next chapter. The process exists to answer three fundamental questions that every divorcing couple must face. These are the three mountains you have to climb. How do we divide what we own? How will we parent our children? And how will the finances flow between us to ensure everyone is supported? Answering those three questions is the entire point of the legal journey. So let's start climbing that first mountain, dividing what you own. This is officially called property division, and it can feel like trying to untangle a decade's worth of Christmas lights. The goal, in the eyes of the law, is to arrive at a fair separation of your financial lives. But here's the first major fork in the road you need to be aware of, because what's considered fair depends entirely on where you live. The United States doesn't have one set of rules. It has two completely different systems. The first system is called community property. Only a handful of states use this, but they're big ones like California, Texas, and Arizona. The concept is simple, at least on the surface. Imagine a big bucket. From the day you say, "I do," almost everything you earn, acquire, or buy gets thrown into this community bucket. Your salary, the house you bought together, the retirement funds you contributed to, it all goes in. Under community property law, that bucket belongs to both of you 50-50. When you divorce, the starting point is to simply split the contents of that bucket right down the middle. Sounds straightforward, and sometimes it is. But the arguments start over what, exactly, was thrown into that bucket in the first place. The second system, which is used by the vast majority of states, is called equitable distribution. And this is where the word fair gets a lot more subjective. Equitable does not mean equal. It doesn't automatically mean 50-50th. It means what the court deems to be fair and just under all the circumstances. So instead of a simple 50-50 split, a judge in an equitable distribution state will look at a whole list of factors. Things like the length of the marriage, the age and health of each spouse, the income and earning potential of each person, the contributions each person made to the marriage, and this is critical, that includes the contributions of a stay-at-home parent. The law recognizes that raising children and managing a household has real economic value, even if it doesn't come with a paycheck. So a spouse who gave up a career to support the family isn't just left out in the cold. Their non-financial contributions are weighed in the balance. In these states, a division could be 50-50, but it could also be 60-40ths or even 70-30ths if the circumstances warrant it. It's all about achieving a fair outcome, not a mathematically perfect one. So whether you're in a 50-50 state or a fairness state, the next step is the same. You have to figure out what property you're actually dividing. This brings us to two of the most important terms you will learn in this entire process: marital property and separate property. Marital property is basically everything you and your spouse acquired during the marriage. That word "during" is key. It's the stuff that went into that community bucket we talked about. This includes the obvious things: the family home, cars, bank accounts, furniture. But it also includes things you might not think of as shared. For example, the 401k or pension that's in your name. The portion of that retirement account that grew from the day of your marriage to the day of your separation is typically considered marital property. It doesn't matter whose paycheck funded it. If a business was started by one spouse during the marriage, that business and its value are likely marital property. Even credit card reward points or frequent flyer miles accumulated during the marriage can be considered marital assets. The law generally views a marriage as an economic partnership, so the fruits of that partnership belong to the partnership itself. Then you have separate property. This is the stuff that belongs to each of you individually, even though you're married. The definition is pretty specific. First, it includes anything you owned before the marriage. That car you had in college, the savings account you started with your first job, the stocks you bought before you ever met your spouse, that's yours. Second, separate property includes inheritances received by one spouse, even if they were received during the marriage. If your grandmother leaves you her house in her will, that house is your separate property. Third, it includes gifts given specifically to one spouse from a third party. If your parents give you $10,000 for your birthday, and it's clear the gift was just for you, that's your separate property. Now this all sounds pretty clean and neat. You have a pile for marital property and two smaller piles for each person's separate property. Simple, right? Well, this is where real life gets messy, because over the course of a 5, 10, or 20-year marriage, those piles get mixed up. And when separate property gets mixed with marital property, we have a legal concept called commingling. And this is where so many of the battles are fought. Let me give you the classic example. Let's say you inherited $50,000 from your uncle. That's your separate property. But then you and your spouse decide to buy a house. You use that $50,000 inheritance as the down payment. You deposit it into your joint checking account, and then write the check from there. You've just commingled your separate funds with marital funds to buy a marital asset. By doing that, you may have just converted your separate property into marital property. That $50,000 might no longer be considered just yours. It could now be seen as a gift to the marriage, and that house and all the equity in it is now a marital asset to be divided. The same thing can happen with a premarital home. Maybe you owned a condo before you got married. That's your separate property. But after you get married, you both live there. You use money from your joint checking account, which is marital money, to pay the mortgage, the property taxes, and to remodel the kitchen. Over the years, the value of that condo goes up. The increase in value that happened during the marriage, especially the increase that can be tied to those marital contributions, is now likely considered marital property. So the condo is no longer 100% yours. It's become a hybrid asset, part separate and part marital. Untangling this is a huge part of the legal process, and it often requires forensic accountants to trace the money and figure out who is entitled to what. And let's not forget the other side of the balance sheet. We've been talking about assets, the things you own. But the court divides debts too. Mortgages, car loans, student loans, and especially credit card debt. Any debt incurred during the marriage for a family purpose is generally considered marital debt. And this is a huge shock to many people. It doesn't matter whose name is on the credit card. If your spouse ran up a $20,000 bill on their personal Visa card buying groceries, clothes for the kids, and paying for family vacations, that's a marital debt. You are likely on the hook for half of it, even if you never use the card yourself. On the other hand, if your spouse ran up that same debt on a secret shopping spree or a trip to Vegas you knew nothing about, their lawyer will have a much harder time arguing that it was for a family purpose. So the first massive task in any divorce is a full accounting. It's called financial discovery, or disclosure. You and your spouse will be required to exchange complete and honest information about everything you own and everything you owe. Bank statements, pay stubs, tax returns, retirement account statements, loan documents, everything. You create a master list of all your assets and all your debts. Then you go down the list item by item and try to agree on 3 things. First, is it marital or separate property? Second, what is it worth? You might need to get the house appraised or have a business valuation done. And third, who gets it? You can agree that one person keeps the house and the other keeps an equivalent amount from a retirement account. You can agree to sell the house and split the proceeds. There are 1,000 ways to slice the pie. The goal is to reach an agreement that you both can live with, and that a judge will sign off on as being fair and equitable. This negotiation is the heart of the property division process. It's a daunting task, full of emotion and complexity. But understanding these core principles, community property versus equitable distribution, marital versus separate property, and the commingling of assets and debts, is the essential first step to navigating it successfully. Once you have a clear picture of your financial world, you can begin the work of dividing it. But for many people, the financial mountain, as big as it is, pales in comparison to the next one we have to climb. And that next mountain, for anyone with children, is the one that casts the longest shadow. It's the one where every step feels weighted, every decision monumental. Because this isn't about assets or bank accounts anymore. This is about the little human beings you created together. This is about custody and co-parenting. Let's be brutally honest. Nothing in a divorce can detonate with more force than the issues surrounding your children. It's where love, fear, anger, and a fierce protective instinct all collide. And it is, without a doubt, the single most important area to get right. Your financial future is important. Your emotional healing is critical. But how you handle this next phase will echo for decades in the lives of your kids. The very first thing that has to happen is a profound and often painful mental shift. You have to consciously separate your role as a spouse from your role as a parent. The spousal relationship is ending. The co-parenting relationship is just beginning. And it will last for the rest of your lives. I want you to hear that again. The person you are divorcing will be in your life, in some capacity forever, through your children. At graduations, weddings, the birth of grandchildren. Your ability to transition from partners in marriage to partners in parenting is the ultimate predictor of your children's well-being through this process. This means you must commit, right now, to putting your children's needs ahead of your own anger or hurt. It means you will not use your children as messengers. You will not use them as pawns in a strategic game. You will not badmouth your ex-spouse in front of them. This isn't just a nice idea. It's a survival strategy for your children's emotional health. They are half you and half your ex. When you attack your ex, your child hears it as an attack on a part of themselves. Now let's wade into the legal terminology because it can be confusing and intimidating. In the United States, when we talk about custody, we're generally talking about 2 different things: legal custody and physical custody. Legal custody is about decision-making power. Who gets to decide on the big stuff? We're talking about major life decisions. What school the child attends, what religion they're raised in, non-emergency medical procedures like getting braces. In most cases, courts heavily favor joint legal custody. The court's default position is that both parents are fit and capable, and should have an equal say in these major decisions. It's like you're both on the board of directors for Kid Incorporated. You might not agree on everything, but you both have a vote. Sole legal custody, where one parent makes all these decisions alone, is rare. It's typically only awarded in extreme situations involving abuse, neglect, severe substance abuse, or a complete inability of one parent to be involved. Then there's physical custody. This is what most people think of when they hear the word custody. It's about where the child lays their head at night. This is about the day-to-day parenting schedule. Just like with legal custody, there's joint and sole. But here, the variations are almost infinite. Joint physical custody doesn't always mean a perfect 50-50 split. It just means both parents have significant, frequent periods of time with the child. This could be a week-on, week-off schedule. It could be a 2-2-5-5 schedule, where one parent has Monday and Tuesday, the other has Wednesday and Thursday, and you alternate weekends. It could be any number of arrangements that work for your family. Sole physical custody means the child lives primarily with one parent, often called the custodial parent, while the other parent, the non-custodial parent, has a set schedule of visitation, or what's now more commonly called parenting time. This could be every other weekend and one dinner a week, for example. The trend in family courts across the country has been moving steadily towards maximizing both parents' time with the children, leaning heavily towards joint physical custody arrangements, unless there's a compelling reason not to. The court's primary, and often only, concern is the best interest of the child. Your wants, your needs, your convenience, it all comes second to that standard. So how do you figure all this out? You create something called a parenting plan. This document is the single most important piece of paper you will create during your divorce. It is the roadmap for how you will raise your child as co-parents. A vague plan is a recipe for constant conflict. A detailed, comprehensive plan is a recipe for peace. It's your rule book. When a disagreement arises, you don't argue. You consult the plan. A strong parenting plan should cover everything. And I mean everything. First, the regular residential schedule. Lay out the specific days and times for exchanges. Who has the kids on which weekdays? How do weekends work? Be precise. Sunday evening is not good enough. Is it 6 p.m.? Is it after dinner? Where does the exchange happen? At a parent's home? At school? The more detail, the less room for future fights. Second, holidays and vacations. This is a huge source of conflict. You need to map out the entire year. Who gets Thanksgiving in even years? Who gets it in odd years? How do you split the winter school break? Do you alternate the first half and the second half, or alternate the entire break year to year? What about Mother's Day and Father's Day? The child's birthday? Your birthdays? And what about summer vacation? How much uninterrupted vacation time does each parent get? How much notice do you have to give the other parent about travel plans? Put it all in writing. Third, decision making. If you have joint legal custody, how will you actually make decisions together? Your plan should specify that you must consult each other on major decisions. What happens if you can't agree? Your plan can build in a dispute resolution process, like requiring you to attend a session with a mediator or a parenting coordinator before heading back to court. Fourth, communication. How will you and your co-parent communicate about the kids? Many plans now mandate the use of a co-parenting app, like Our Family Wizard or Talking Parents. These apps keep all communication in one place, it's documented, and it often has a tone meter to prevent hostile language. It keeps the focus businesslike, on logistics, not lingering resentments. And finally, you need to think about future contingencies. What happens if one parent wants to move? You need a relocation clause that defines how far a parent can move without the other's consent or a court order. What about the right of first refusal? This means if a parent needs a babysitter for a certain amount of time, say more than 4 hours, they must offer that time to the other parent first before calling a grandparent or a sitter. Creating this plan is hard work. It forces you to confront dozens of potential future conflicts. But every issue you resolve now is one less battle you have to fight later. One less source of stress for your kids. Whether you create this plan together in mediation or it's decided by a judge in court, having a detailed plan is non-negotiable. Because as you build this new life, this new two-home family, your children will be watching. They absorb everything. They need to see that even though their parents aren't married anymore, you are still a team when it comes to them. They need to be given permission to love both of you, freely and without guilt. They need to be reassured over and over that the divorce is not their fault. They need stability, predictability, and to know that they are safe and loved. Your parenting plan is the architecture for that safety. It's the structure that holds their world together when the foundation has cracked. Mastering this new co-parenting dynamic is a journey, not a destination. And it's a critical piece of the puzzle that allows you to finally turn the page and begin the last chapter of the divorce process itself. This final chapter is where the legal process meets your new reality. It's about the final paperwork, the emotional closure, and the first intentional steps you take into a life that is now solely yours to design. Let's talk about finalizing the divorce. After the negotiations, the mediation, the back and forth, you'll arrive at what's called a marital settlement agreement or a separation agreement. This is the master document. It contains every single detail you've agreed upon. The division of every asset and debt, the custody plan, the child support and spousal support arrangements. This document is the blueprint for your separate futures. Read it. Then read it again. Have your attorney explain every clause you don't understand 100%. This isn't the time for assumptions. Once both parties sign it, this agreement is typically submitted to the court. In many cases, you might have a final brief court hearing. For some, this is a simple administrative step. The judge reviews the agreement, confirms that both parties understand and agree to its terms, asks a few standard questions, and then with the bang of a gavel or the signing of a document, it's done. The judge will issue a final decree of divorce. This is the official court order that legally terminates your marriage. That piece of paper is what you'll need to change your name back, to refinance a house, to prove to the world that you are legally single. Getting that decree can feel surreal. For months or even years, this has been the goal you've been fighting for, working towards, and maybe even dreading. And then, in a quiet, anticlimactic moment, it's over. The war is won, the battle is finished. But now you're standing on the battlefield alone, and you have to figure out how to go home. This is where the real work begins. The legal divorce is an event, but the emotional divorce is a process. And it doesn't follow a neat timeline. The moment the divorce is final, you might expect to feel a wave of pure relief. And you might. But you also might feel a profound sense of sadness. You might feel anger, confusion, anxiety about the future, or a deep, hollowing grief. All of these feelings are valid. You are not just grieving the end of a relationship. You are grieving the future you thought you were going to have. The family holidays, the retirement plans, the inside jokes, the simple comfort of having a person who knew your story. That loss is real, and it deserves to be mourned. Allow yourself the space to feel it without judgment. Pushing it down or pretending you're fine only delays the healing. Think of it like a physical wound. You can't just ignore it and expect it to get better. You have to clean it, tend to it, and give it time to scar over. It will always be a part of you, but it doesn't have to hurt forever. As you navigate this emotional landscape, you must simultaneously take concrete, practical steps to rebuild your life. The first and most critical area is your finances. Your marital settlement agreement is a map, but you are the one who has to do the driving. This is your financial day one. First, execute every single financial task laid out in the decree. If you're supposed to refinance the mortgage to get your ex-spouse's name off the loan, start that process immediately. If you need to divide a retirement account using a special court order called a QDRO, get the paperwork started. These things can take time and have serious financial consequences if ignored. Next, it's time to separate everything. Close any joint bank accounts and open new ones in your name only. Do the same for credit cards. This is not about mistrust. It's about creating a clean financial break and protecting yourself. You are no longer legally responsible for their spending, and you need your accounts to reflect that. Then comes the crucial and often forgotten step: updating your beneficiaries. Your life insurance policy, your 401k, your IRA, chances are your ex-spouse is still listed as the person who gets everything if something happens to you. Unless that is your intention, you need to change that immediately. This single piece of administrative housekeeping can prevent a world of legal and emotional chaos for your loved ones down the road. Finally, you need to create a new budget. Your income and expenses have changed dramatically. You need a clear, realistic picture of your new financial reality. It might be scary and it might be tighter than you're used to, but knowledge is power. A budget isn't a restriction. It's a tool that gives you control over your new life. Beyond the finances, your social world will likely shift. This can be one of the most painful and surprising parts of a divorce. Friends you had as a couple may feel forced to choose sides. Some may simply fade away, uncomfortable with the new dynamic. It hurts. It feels like a secondary rejection on top of the one you've already endured. But this process, as brutal as it is, reveals who your true support system is. Lean on them. Be honest about what you're going through. And be open to forming new connections. Join a club, take a class, volunteer. Find people who know you as the individual you are now, not as one half of a couple you used to be. This leads to the biggest, most existential task of all: rediscovering who you are. For years, your identity has been intertwined with your partner's. You were a we. Your decisions, your weekends, your future plans, they were all made in the context of a partnership. Now you are an I. And that can feel both terrifying and incredibly liberating. Who are you without that other person? What do you enjoy? What are your dreams just for you? This is your chance to find out. Reconnect with hobbies you let slide. Travel to a place your ex never wanted to go. Eat cereal for dinner just because you can. Get comfortable in your own silence, in your own company. This isn't about filling the space your partner left. It's about expanding into the space that is now entirely yours. As time goes on, a new normal will begin to emerge. The co-parenting exchanges will become routine. The holidays will have a different, but still special rhythm. The empty side of the bed will just become your side of the bed. You'll start to think about the future not as a scary unknown, but as a blank canvas. And inevitably, the question of dating will come up. There is no magic timeline for when you should start dating again. The only right answer is when you feel whole on your own. If you're dating to avoid being alone, to prove you're still desirable, or to fill a void, you're likely to repeat old patterns. But when you're dating because you want to share your already happy and complete life with someone else, that's when you're ready. The journey through divorce is a marathon, not a sprint. It is a process of deconstruction and reconstruction. You have taken apart a life that was no longer working piece by painful piece. You've sorted through the rubble, kept what was worth saving, and discarded what was holding you back. And now you stand on a new foundation. It may be a foundation you never asked for, one you never wanted to build. But it is yours. From this day forward, you get to be the architect of your own life. You get to choose the colors, design the rooms, and decide who gets an invitation to walk through the front door. It will not be easy, but it will be authentic. Divorce is not the end of your story. It is the end of a chapter. And the next one is waiting to be written. You hold the pen.